Hello, students. Today we are having a discussion basically on the provision of Section 498A, that is cruelty. And this particular case law basically reiterates certain basic interpretive aspects of Section 498A. So, without wasting any time, we can directly go into this particular case law. So the name of the case law is Aluri Venkata Ramana versus Aluri Thirupathi. And as I said, it is in relation to section 498A. So before we go into the facts of the case, I prefer that we have a look at the provision itself, which is provided in the judgment. So now what is 498A? It basically is a provision which provides certain protections to women and women who come under the ambit of a certain category, right? And the section starts off with saying that whoever, being the husband or the relative of the husband of a woman, so has to be a husband or a relative of the husband of a woman, subject such woman to cruelty, shall be punished with imprisonment for a term which may extend to 3 years and shall also be liable to fine. The explanation to this provision is actually what is relevant to our discussion today, where they state that cruelty means a willful conduct which is of a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, whether mental or physical, of the woman, or harassment of the woman, where such harassment is with a view to coerce her or any person related to her to meet any unlawful demand for any property to valuable security, or is an account of on account of failure by her or any person related to her to meet such demand. Now, on a reading of this provision, there are certain facets which become clear. One, that it protects a woman against her husband or the relative of the husband, and that it protects them, these women, these category of women, from cruelty, which is defined either to mean something which creates through the conduct of these individuals a situation where such woman is driven to commit suicide, or causes grave injury or danger to life, limb, or health, and this could be mental or physical in context of the woman. And then it provides another category stating that it can also mean harassment in context of wanting some kind of property, a demand for property or valuable security which is unlawful, and that this harassment is in context of the demand or in account of failure of her to fulfill that demand. Now, coming to our case, a debate on the interpretation of this half comes into picture. What is our case? It revolves around a couple, and this couple who are married in 2005. In 2015, a certain issue crops up in context of an amount of rupees 40,000 which the husband gives to the family of the wife, and in context of the repayment of that amount there is friction between the couple. This leads to the husband, and along with another individual, raising his hands on the wife, which is sorted out by the wife and her relative, a maternal uncle, who states that he will repay whatever this amount is. And after this discussion, subsequently, again in a day or two, the husband, along with another individual, again beats the wife. At this point, now the wife has also tried to, she leaves the home, she leaves the matrimonial home and tries to return to the home, is not allowed to enter the home. And during this time, this particular case is filed wherein she makes the husband, the mother-in-law, and multiple other individuals who were involved in the incident from the side of the husband a party to a complaint against, which is or under allegations again 498A, along with section 34 of IPC, which is common intention. Now, on investigation, the magistrate took cognizance of the case against the husband and the mother-in-law, and the rest of the individuals he did not take, or he dropped the rest of the individuals and restricted it to only the husband and mother-in-law. Now, aggrieved by this, the two accused went to the High Court. Now, here the issue begins, wherein the High Court accepted the submission of the accused, which basically amounted to the fact that the allegations did not anywhere prove that there was any kind of demand of dowry on behalf of the appellant. And their argument was that 498A, through its interpretation of the section holistically, requires that there must be some demand in context of dowry. Right? That is what has been highlighted here for it to come under the ambit of cruelty. And the High Court, therefore, now has a discussion on does or do both of these meanings or explanations to cruelty require the facet of demanding of dowry. On our reading of the provision, we understood that cruelty could be defined in two ways, and they are disjuncted by the use of the word, or they are separated from one another. So, plain reading in itself shows us that actually, in the first half, if you have a willful conduct which drives either the woman towards committing suicide or causes injury, grave injury or danger to her life, limb, or health, and in aspect of physical and mental health, the ambit could come in. And the second half talked about actually in case of there being a demand or a demand of property or valuable security, and in context of that, harassment has taken place to this woman, again would come under the ambit of cruelty. So, the argument which the accused put up towards the High Court was that both of these provisions require the aspect of dowry. And now in the Supreme Court, the question has come up that does this particular provision really require a demand, or is it limited only to this particular subset or subcategory of the explanation? So the Supreme Court heads towards different facets, and initially itself says that when it was introduced in 1983, its primary objective was to protect married women from cruelty at the hands of husband and her in-laws. It provides a broad and inclusive definition of cruelty, encompassing both physical and mental harm to the woman's body or health. And additionally, it covers harassment designed towards coercing the woman or her family towards fulfilling unlawful demands of property or valuable security, which includes within it a demand of dowry. So basically, this language, due to the aspect of unlawful demand for property or failure of fulfillment of unlawful demand of property or valuable security, includes within it the demand for dowry. Right? So a subset of the second explanation is a demand for dowry. So the court has already explicitly in this para told us first half deals with physical and mental harm which is caused by the husband, and in addition the second harm deals with unlawful demands for property or valuable security which includes within it a demand for dowry. It also brings within its ambit a situation of circumstances which leads an individual to commit suicide, the woman to commit suicide. In the first half, we see that cruelty includes creating circumstances where the woman wants to commit suicide or is in a situation of grave harm that can be done to her mind or body. Furthermore, the court has stated that harassment under the explanation to 498A is specifically outlined in clause B. It has been used in clause B, and the terminology used in clause A is of willful conduct, a willing conduct to cause harm to the woman, right? Thus, it necessitatingly separates the two types or forms of cruelty which have been defined in the two provisions. Clause A provides for cruelty in the context of willful conduct where harm is caused to the individual, which is the woman, the wife, and that can be mental or physical harm. And the second one, which is disjuncted from the first one through the word or, is harassment, which relates to unlawful demands for property or valuable security, which includes dowry, right? Which includes the facet of dowry. These forms can coexist, which means that in certain situations there may be A plus B, right? That means that there is harm, there is some kind of grave harm that can happen to the wife through the husband or his relatives, and additionally there may be also unlawful demands of property, including those that of dowry, which can take place in context of this, in context of wives. So there can be situations of cruelty where both situations are present, they coexist, but it does not at any point mean that if the dowry related demand is not present, then the action of cruelty does not survive or the allegation of cruelty does not survive. So it can also happen that in certain situations there is no such unlawful demand of property or valuable security, but there is harm that the wife might face, physical or mental harm, and in context of that also cruelty can be alleged on the husband and his relatives. So in interpreting the provision, the court says it is crucial to consider the broader objective behind its introduction, that is to protect and safeguard women from every and all forms of cruelty, right? Regardless of whether the nature of the harm inflicted includes a specific demand of dowry or not. So the court is hinting towards the fact that it is not necessary that there must be in all allegations of cruelty and unlawful demand for dowry. It is a protection which is given to women in order to safeguard them from all forms of cruelty, which includes harm or threat of harm or injury, which can be mental or physical in nature. The court goes ahead and even points out the objects and reasons which were provided when this provision was introduced. And it stated that the objects and reasons provided that IPC, CRPC, and Indian Evidence Act must be changed in order to deal with incidents or cases of dowry death and also cases of cruelty to married women in by our laws. So there must not only be in context of dowry related offenses a change in the provisions, but also saying independently cruelty is something against which women or wives should be protected. So again the court is trying to point out that the last line hints that 498 of IP 498A of IPC is not about only cruelty in context of dowry demand, but also cruelty to married women by their in-laws in general, not restricted only in context of demands of dowry. And therefore, they further again add that it is not restricted, the definition of cruelty is not restricted and not to be interpreted relating only to demand of dowry. A landmark case is again referred, that is US Saveta versus State, to establish the ingredients of 498A, which is that it must be a married woman. She must either face cruelty or harassment. Harassment in context of property demand, unlawful demand, and cruelty in context of the harm could be one interpretation that was brought in. Such cruelty or harassment must have been shown by the husband of the woman or relatives. In essence, what we are trying to establish is that nowhere, even in this landmark case, do the ingredients which were introduced or established by the case, is there a requirement that both explanations require a demand for dowry, right? In fact, it is the element of cruelty and harassment which have been divided and put in, hinting towards the fact that all forms must be included and not limited only to those forms which include demand of dowry. Another case which has been cited is Arvind Singh versus State of Bihar. If you want, you can look at the citation. It states that the intent of 498A is clear, and that is to indicate that in the event of there being a state of conduct by the husband to the wife or by any relative of the husband, which can be attributed to be painful or distressing, the same would be within the meaning of the section. So, again, the court through this case law is trying to reiterate that what is referred to is not necessarily the requirement of a dowry demand or the demand for any kind of unlawful property, but that which looks to be painful or distressing for the wife and has been done by the husband or the relative of the husband. The court reiterated that the High Court made a mistake in relieving the appellants in this particular case by assessing cruelty in the context of dowry related demands only. Right? It did not, the High Court did not give sufficient reasoning in context of why it relieved the allegations against the appellant. It primarily was influenced by dowry related demands lacking in this particular case and did not interpret the term cruelty correctly in context of the explanation that has been provided. The respondents, as in this particular stage in the Supreme Court are the accused, have gone ahead and again made the statement and reiterated the fact that A and B must be read in context of a demand of dowry, in context of demand for property or valuable security. But the court has concluded, in the light of the discussion above, it is submitted, the submission is considered without merit and is not accepted by the court. They don't feel that the interpretation of the argument which has been put forward by the respondents is acceptable in the light of the discussions which we have already had and the references to the object and reasons and the case law in context of the interpretation of 498A. Lastly, the court has said that they have to be read disjunctively. What are they? The explanations A and B of 498A. Meaning that the presence of dowry demand is not a prerequisite for establishing cruelty under the section. The allegations made by the appellant, which detail instances of physical abuse and harassment, fall within the scope of cruelty as defined under Clause A. The absence of an explicit dowry demand does not negate the applicability of the provision where acts of physical violence and mental distress have been demonstrated. The High Court has erred in quashing all criminal proceedings against the accused, and the trial ought to have been allowed and carried out. And therefore, the appeal in front of the Supreme Court was allowed. In short, we come back to the fact that in this situation, where we see the two explanations of 498A, they are disjunctive in nature, and the explanation A does not require the presence or the requisiteness of a dowry demand, while in B, we see that an unlawful property demand could within its ambit and can within its ambit bring in the context of dowry demand. So here it is acceptable and it can be brought under the umbrella of explanation B, but explanation A does not require within it for the establishment of cruelty that there must be a demand for unlawful property or valuable security. I hope, students, that I was able to clarify this latest case law which provides and re-establishes interpretation on 498A and whether it requires dowry as a prerequisite in its allegations in context of the interpretation of the word cruelty. Thank you, students.